Preksha ma'am, am I audible?
Yes, Sanjana.
Thank you. So, good afternoon, everyone. Thank you for joining us for today's session. So, my name is Sanjana, and I'll be your host for this session. So, before we begin, a few quick housekeeping notes I'll be sharing with you. So, the first is this webinar is scheduled to last approximately for 1 hour, including a question and answer session at the end. We have muted all the attendees to ensure the best audio quality for our speaker. We encourage you to submit your question at any time throughout the presentation using the chat box. Our team will be collecting them and we'll address as many as possible during the dedicated question and answer segment. A free certificate of participation will be provided to all the attendees who still who stay till the end. Today's session is being recorded, and in case you miss out, you can go back to onto our YouTube channel to check the video. So now I'll be discussing the details of today's topic. The topic of arbitrability in intellectual property rights dispute is particularly relevant and timely in a world where innovation and creativity are at the forefront of economic growth. The need for efficient and effective dispute resolution mechanism for patent, trademark, and copyright has never been greater. The debate over whether these complex and often technical disputes can be resolved through arbitration, an alternative to traditional court litigation, is crucial for both legal practitioners and businesses alike. Today, we will be diving into the concept of arbitrability, recent judicial development in India, and comparative global perspectives on the fascinating subject. Our discussion aims to provide practical insights that will be invaluable for young lawyers and professionals navigating this evolving area of law. Now, it is my great pleasure to introduce our distinguished speaker for today, Advocate Balaji Iyer sir. Advocate Balaji sir is a Master of Laws graduate from Humboldt University of Berlin, specializing in international dispute resolution. He is an accomplished advocate, arbitrator, and mediator with a unique blend of academic rigor and practical expertise. Since being accredited as a civil and commercial mediator by ADR Group, his practice has been committed to resolving disputes efficiently and equitably. He is also certified as a tribunal secretary by the Mumbai Center for International Arbitration. Balaji's Balaji sir's core competencies include dispute resolution, legal writing, and legal research. His multilingual skills in English, Hindi, Kannada, Tamil, Malayalam, and German allow him to connect with the diverse client and facilitate effective communication. He has extensive experience in the legal field, having worked as an advocate at the Chamber of George Rebello and Arna Law in Bangalore, and as a neutral at various organizations like WebNyai, Cadre ODR, and Just Act. So, without further ado, please join me giving a warm welcome to Advocate Balaji Iyer, sir. Sir, please.
Uh, Hi, thank you for having me. It's a great pleasure to interact with everyone today. I assume a lot of you will have some questions throughout the presentation. As Sanjana has already pointed out, my only request is that you send across your questions. Use the raise hands feature. Send across your questions, and the team will put together question bank, a common question bank, which I will try to answer at the end of the presentation. If Can I just, before we begin, can I just know by a show of hands, feel free to use the raise hand feature. How many of you all here are students today? And if you're students, which year are you in? You can put it in the chat box. Uh, right. So I have seen a lot of the responses that are coming in, and a lot of you are students spread across the uh, b- across all years of both the 3-year and 5-year programs. So uh, now I'll start. I know where I have to start the presentation from. We'll start with some of the basics. Uh, Please let me know if you can see my screen. Right. So the topic of today's discussion is arbitrability of IPR disputes. Uh, this is something that this is a topic that is still emerging in the legal fraternity, because what is arbitrable and what is not arbitrable is an evolving concept. Today, I will try and give you a definition of what arbitrability actually means. We will go through some of the principles that have evolved in India as far as what is arbitrable and not arbitrable is concerned. Uh, we'll take a look at the Vidya Drolia case, which is the latest case and lays down the fourfold test to determine arbitrability. Uh, and given the context of that case, can that test be adopted into IPR disputes is something that we will take a look at. And then we'll take a look at some other countries. I have selected the UK, Singapore, Germany, and WIPO, which is the World Intellectual Property Organization. So what exactly is uh, arbitrability? Arbitrability means determining which disputes are capable of being resolved through arbitration and which disputes are not capable of being resolved through arbitration. Now, that is really the long and short of it. If you talk about Indian law and you look at the Indian Arbitration and Conciliation Act, the concept of arbitrability is embedded in Section 7 of the Arbitration and Conciliation Act 1996. So what does Section 7 say? I'll just read out. It defines, Section 7 of the Arbitration and Conciliation Act defines what an arbitration agreement is. Now, a key distinction that is to be kept in mind here is uh, in order to arrive at a determination of what is arbitrable and what is not arbitrable, you have to keep in mind the distinction between two kinds of rights: public rights or in rem rights, and private rights or in personam rights. Private rights or in personam rights are rights that concern two or more individual private contractual parties. So you have a party A, you have a party B, they both enter into an agreement, and disputes arise between them under that, in connection with or out of that agreement. Those disputes concern in personam rights because you are determining the rights as between those two individuals A and B. Whatever happens to that dispute between A and B does not affect anybody else, any third party C, D, X, Y, Z. It only concerns those two parties A and B. Those are all those rights which arise in such a manner are called in personam rights or private rights. Now, what are in rem rights? In rem rights are rights of an individual that affect the public at large. So, a declaration that this house belongs to me, or this piece of land belongs to me, or this car belongs to me, or to identify something as belonging to a particular individual as against everybody else in the world, that is a public right. Now, both in terms of intellectual property rights, you have both uh, in rem rights or public rights and in personam rights or private rights. In rem rights, examples of in rem rights in the IPR context would be the validity or invalidity of a trademark registration. Should it be allowed to be registered under the Trademarks Act? Is it is the registration of a particular trademark or the use of a particular mark infringing somebody else's trademark? These are all public rights. The trademark holder, for example, is claiming that he alone has the right to use that particular mark as against everybody else in the world. And therefore, if anybody else uses that mark, irrespective of whether there is an agreement for usage between the holder of the trademark and the other person, there is an infringement of my trademark as against the rest of the world. in personam rights in IPR disputes are things like licensing or royalty agreements. I, as a trademark holder, want to give my trademark to somebody else for a particular period, and in that particular period, the person to whom I am licensing or assigning the trademark will give me some money for using that trademark. So if any disputes arise out of this particular arrangement between me and the person who is the licensee or the assignee of the mark, then those are in personam rights. It doesn't involve the rest of the world. It only involves me and the licensee. So these are in rem and in personam rights. They both exist in the IPR context, uh, depending on how you are looking at it. Now, uh, returning to this, now how exactly does it matter if certain rights are in rem and certain rights are in personam? Or to put it another way, how does it matter if, for as far as arbitration is concerned, if certain rights are public rights and certain rights are private rights? For that, we'll take a look at three cases, two Supreme Court cases and one Bombay High Court case, which deal with exactly this concept of in rem and in personam. And then we'll move on to take a look at the Vidya Drolia case, which lays down the test for determining arbitrability and non-arbitrability and how in rem and in personam comes into play over there. The first case is of Booz Allen Hamilton versus SBI Home Finance. It's a more than a decade-old case now, but it was really the first case that dealt with this concept of arbitrability in rem and in personam rights. The facts of the case are this. There were a couple of flat owners who took a home loan from State Bank of India, and in consideration of receiving that loan, they mortgaged their properties to the bank. Booz Allen Hamilton wanted to occupy these particular flats. To occupy these particular flats, the consent of SBI, the bank to whom the property had been mortgaged, would have been required. So Booz Allen Hamilton entered into a tripartite agreement with these two flat owners, two separate tripartite agreements, one with flat owner A, one with flat owner B, entered into a tripartite agreement with the flat owner and SBI to occupy the flat under a leave and license agreement. The deposit that Booz Allen Hamilton had to make went to SBI. And that deposit agreement, the tripartite agreement that we are talking about, that agreement contained an arbitration clause among the three parties, Booz Allen Hamilton, the flat owner, and the bank. Now the flat owner defaulted on the loan, and SBI promptly filed a mortgage suit. That is a suit to attach the property which has been mortgaged to the bank, sell it off, and recover the loan from the sale proceeds of that flat. Now, the problem that SBI faced was the flat owner who had actually taken the loan was not in possession of the flat. It was being occupied by somebody else, that is Booz Allen Hamilton. So in order to get the possession of that flat, SBI also had to simultaneously compel Booz Allen Hamilton to vacate the property, and this is what they tried to do. Now, Booz Allen Hamilton entered appearance in that mortgage suit and requested the court to refer them to arbitration, saying there is a tripartite agreement between or among me, Booz Allen Hamilton, the flat owner, and SBI. And before SBI can take possession of the flat and sell it off and recover its dues, uh, that has to be that is not to be decided by the civil court. That is something that is to be decided in arbitration. Here, the Supreme Court goes into several questions of arbitrability, not arbitrability, and in rem and in personam, and held that a mortgage suit is not capable of being referred to arbitration. Enforcing a mortgage, which is what State Bank of India was trying to do, involves an action in rem. It affects State Bank of India's right to occupy and possess the property as against the flat owners, as against Booz Allen Hamilton, and everybody else in the world. It is giving an exclusive right, a mortgage suit is giving an exclusive right to SBI to own and occupy and possess that particular property. It affects the entire world, not just these three actors in this particular case. Since a mortgage suit involves an action, is essentially an action in rem and affects public rights, it is not something that is arbitrable. That is what the Supreme Court says in Booz Allen Hamilton. While discussing arbitrability and not arbitrability, the Supreme Court gives examples of several other non-arbitrable matters, including criminal cases, matrimonial cases, cases involving questions of guardianship, insolvency, and testamentary cases. These are the actual examples that the Supreme Court gives in the Booz Allen Hamilton case. And somewhere along the way, intellectual property rights is also, the word IPR is also put into that particular paragraph. My personal view of the Booz Allen Hamilton case and why it's a good starting point is, after 2011, whenever the question of arbitration in the IPR context came up, courts were encouraged to look at the subject matter of the dispute. Oh, it is an intellectual property rights case. And courts would say, Booz Allen Hamilton says IPR is non-arbitrable. And therefore, your arbitration clause, there may be an arbitration clause between you and your disputing party, but it cannot go to arbitration at all, because as a subject matter, the Supreme Court has held IPR is non-arbitrable. They're relying on Booz Allen Hamilton, which is an incorrect application of Booz Allen Hamilton itself. Intellectual property rights cases is just one example that Booz Allen Hamilton gave to determine, to say these are some matters that are non-arbitrable, but that is where the confusion started. It was a misinterpretation of that particular paragraph. The next important case in this whole question of arbitrability is the Ayyasamy versus Paramasivam case, again Supreme Court 2016. This was a dispute under a partnership agreement among 5 brothers. The father of these brothers was a hotel owner in Tamil Nadu. After his death, the sons, that is these 5 brothers, took over that business. They entered into a partnership agreement, and a dispute arose between 2 blocks of brothers. the eldest brother on one side and the four younger brothers on the other side. The four younger brothers alleged that the eldest brother was uh, engaging in fraudulent activities in while administering the hotel business. They went ahead and filed a civil suit against the eldest brother. The eldest brother came in and said, "This is the partnership agreement. The dispute relates to us as partners. The partnership agreement has an arbitration clause. So please refer this matter to arbitration under Section 8 of the Arbitration and Conciliation Act." He files an application. This application is resisted by the four brothers who are plaintiffs in the civil suit, and they say that there are allegations of fraud against our elder brother. He has mismanaged the partnership affairs. He has siphoned funds, and all these questions are not arbitrable. Fraud the question of fraud, it's a criminal matter, and therefore, relying on Booz Allen Hamilton, Supreme Court says criminal matters are not arbitrable. Fraud is a criminal matter. Therefore, this entire case cannot be arbitrated. The Supreme Court distinguishes Booz Allen Hamilton and says there is a distinction between simple fraud and complex fraud. Things such as mismanagement of the partnership affairs, embezzlement of funds, they are all simple fraudulent allegations, and those can be arbitrated. There are things that are more complex in nature in the context or in the larger context of fraud, such as forgery or fabrication of documents. These are actual criminal offenses that were defined in the Indian Penal Code. And since they are in the Indian Penal Code as crimes, those kinds of frauds are non-arbitrable. So, the Supreme Court in Ayasami versus Paramasivam bifurcates fraud itself into arbitrable and not arbitrable. It laid down some kind of a test better than the Booz Allen Hamilton test, but still not. It was at that point of time still not where we wanted it to be in terms of truly defining what is arbitrable and non-arbitrable. Then, around the same time, you had another case happening in the Bombay High Court between Eros International and Telemax. Now, the dispute arose out of a term sheet between Eros, who is a film producer and distributor. If anybody is from Bombay, please raise your hand. So the dispute arose between Eros, which is a big name in Bollywood. It's a film producer and distributor, and Telemax. Now, these two parties entered into a term sheet under which there would be marketing and distribution rights given to Telemax by Eros in consideration for some royalty payments being made by Telemax to Eros out of the marketing and distribution activities done. Telemax, what did Telemax do? Telemax sub-licensed its rights under the term sheet between itself and Eros to other parties, saying they are my sub-distributors and sub-marketers. I have received the rights for X number of films from Eros. So I will give one film to sub-licensee A, one film to sub-licensee B, one film to sub-licensee C, and they will go and distribute it further in the market. I will get some royalty from them, and from that I will pass on some of the royalty that I owe to Eros under the term sheet up to Eros. So it is a chain of contracts. Now, this term sheet importantly had a arbitration clause, and both parties contemplated, Eros and Telemax contemplated, that they would enter into something called a long form agreement, which would have been a more detailed version of the term sheet with more clauses and more pages and more paragraphs. And Eros filed a copyright infringement suit in the Bombay High Court. Bombay High Court has original jurisdiction. So Eros filed a copyright suit in the Bombay High Court, saying that by engaging in the sub-licensing activities, Telemax is essentially violating my copyright in these films that I otherwise have a right to. And there is no long form agreement between Eros and Telemax, and therefore Telemax could not have further sub-licensed or sub-distributed the films without my consent. And in doing so, Telemax has violated my copyright interests. That is what Eros filed the suit for. Now, the Bombay High Court considered this, and Telemax came in and said there is an arbitration clause in the term sheet. Filed an application under Section 8 of the Arbitration and Conciliation Act and said, please, there are disputes, please refer us to arbitration. The High Court is not the correct forum to determine the disputes between myself and Eros. Now, just a bit of trivia. I happened to be there when Eros and Telemax case was argued way back in 2016. I was about 1 year into the practice, and the parties were represented by stalwarts of the profession in Bombay. Mr. Venkatesh R. Dhond was representing Eros International. He's a senior counsel, designated quite some time back. I've had the fortune of briefing him on a few occasions. And Dr. Virendra Tulsapurkar was appearing for Telemax. And again, I've not had the fortune of briefing him, but a stalwart in the profession. He is one of the most brilliant minds when it comes to intellectual property rights cases. He was arguing on behalf of Telemax, and I had the fortune of sitting in that courtroom and listening to both sides. And I've appeared, since then, I've appeared against Dr. Tulsapurkar also. Now, in the Eros International versus Telemax case, what the court held was, yes, the essential argument of Eros was the copyright, intellectual property rights statutes such as the Copyright Act or the Trademark Act do not contemplate arbitration. They have exclusive jurisdiction sections which grants jurisdiction to a certain category of courts to the exclusion of all others. And therefore, when the question between me, Eros, and Telemax is about copyright infringement, that question cannot be determined by an arbitrator. It has to necessarily be determined by the Bombay High Court exercising its original civil jurisdiction. That was the argument from Eros. The Bombay High Court rejected this argument and said, where does Telemax claim its rights from? Telemax is claiming from its rights under the term sheet that has been entered into between Eros and Telemax. It is a contractual right arising out of or in connection with that term sheet, while the subject matter of those rights is copyright or intellectual property rights. The relief itself that is being sought by Eros is something that is capable of being determined by an arbitrator. The courts need not be engaged with it. And when there is an arbitration clause in the term sheet, and that arbitration clause has been brought to the attention of the court under Section 8 of the Arbitration Act, given the context, given that the dispute arises out of that particular term sheet and it is between these two parties, there is nothing that prevents the court from making a reference of that particular dispute to arbitration and sending the parties to an arbitrator. The claim of infringement that has been made by Eros against Telemax arises out of the term sheet itself, and that makes it an in personam right and not an in rem or a public right. That is what the Bombay High Court says in Eros versus Telemax. Come up to now 2020, the Vidya Drolia versus Durga trading case. Now, this Vidya Drolia versus Durga trading case is essentially the anchor point of arbitrability in India. This case involved a tenancy dispute under the Transfer of Property Act, and the earlier case of Himangani Enterprises was relied on to argue that landlord-tenant disputes are non-arbitrable. Now, before we get into the details of what was held in Vidya Drolia versus Durga trading, because that lays down the test really for future cases, let's take a look at what the Himangani Enterprises case says. Now, the Himangani Enterprises case is the Himangani Enterprises versus Kamaljeet Ahluwalia case. It's from 2017 from the Supreme Court itself. That case also concerned a lease deed that had been entered into between the plaintiff and the defendant. The landlord Himangani Enterprises had filed a civil suit for possession of that property as against the defendant Kamaljeet Ahluwalia, arrears of rent and mean profits. The tenant Kamaljeet Ahluwalia applied under the arbitration clause in that lease deed that had been entered into between the two parties and said to the court, hey, listen, there is an arbitration clause, so I am invoking Section 8 of the Arbitration and Conciliation Act and asking you, the court, to refer us to arbitration because this is something that can be determined over there. So the Supreme Court stepped in and said, in the Himangani Enterprises case, the Supreme Court stepped in and said, it is not a case that is capable of being referred to arbitration. It falls in the category of non-arbitrable cases. Why? Because there are tenancy disputes in between the parties. The central question or the central subject matter of the case deals with the interest in an immovable property. These matters are governed by the Transfer of Property Act, which is a special law for dealing with immovable property. And under the Transfer of Property Act, jurisdiction is with the civil courts. Therefore, as there is a special law granting a special kind of court, a special jurisdiction, and these are matters of public interest and public right, it is not a dispute that can be referred to arbitration, and therefore the suit initiated by Himangani Enterprises has to continue, is what the Supreme Court said in 2017. And the court relied on the Booz Allen Hamilton case and said, look, in 2011, we said in the Booz Allen Hamilton case that landlord tenant disputes or disputes relating to immovable property are non arbitrable. We uphold our earlier ruling of 2011, apply that same logic over here and say that this is a transfer of property dispute and therefore it is non arbitrable. In Vidya Drolia, the tenant resisted, that is Vidya Drolia, had leased the property from Durga Trading and resisted our reference to arbitration, relying on Himangani Enterprises and saying landlord-tenant disputes are not arbitrable. This is what has been held by the Supreme Court already in 2017, in 2011, in the Himangani Enterprises case and the Booz Allen Hamilton case. So here again, the Supreme Court reconsidered the question of what is arbitrable and non-arbitrable, and specifically overruled the Himangani Enterprises case. It was a larger bench of the Supreme Court, a 3-judge bench, as against a 2-judge bench in the Himangani Enterprises case. The Supreme Court categorically said landlord-tenant disputes under the Transfer of Property Act, simpliciter, are arbitrable. Those landlord-tenant disputes that are under a special rent control law of a particular state, those are not arbitrable. And we specifically overrule the Himangani Enterprises case, which laid down the incorrect law for the last 3 years. Now, in order to determine whether a dispute is arbitrable or not arbitrable, the Vidya Drolia case lays down a 4-fold test and says a dispute is non-arbitrable when A, it relates to actions in rem, applying that to the IPR context, the validity of a patent or the validity of a trademark. It affects third-party rights. So trademark infringement is something that would affect third-party rights, as I said in the beginning. The right of a person to use a particular mark to the exclusion of everybody else in the world, that is something that affects third-party rights. Anything that involves sovereign or public functions, and anything that is statutorily barred from arbitration. Applying this 4-fold test, you determine whether a dispute is arbitrable or not arbitrable. Now, why is all this important? With this judgment, the Vidya Drolia judgment, the Supreme Court effectively laid down an authority on arbitrability in India. It provides a structured test, the 4-fold test, which is to be applied across subject matters. Although this particular case arose in the context of a landlord-tenant dispute, the test that has been laid down, the 4-fold test, is applicable across different subject matters, which is why I'm saying I'm able to apply it in intellectual property rights as well. And it specifically overruled the bad law of Himangani Enterprises. Now let's see how the Vidya Drolia case, what has happened after the Vidya Drolia case. When you apply the Vidya Drolia case, the 4-fold test, to IPR disputes, these, what you see on the slide, is what are examples of what is non-arbitrable and what is arbitrable. So essentially, all IPR disputes arising out of a contract, like licensing agreements, royalty disputes, assignment of intellectual property, distribution and franchise agreements, these are all arbitrable because they are centered on the contract. Validity of a patent, trademark registration, infringement, passing off, these are all non-arbitrable because they are centered around public rights or in rem rights. And these are some examples of where arbitration clauses, if you are a lawyer negotiating an intellectual property licensing contract with another party, uh, these are the kinds of things in which you can, these are the kinds of contracts in which you can introduce an arbitration clause. Now, how has this been applied practically by following the Vidyadrolya case? For this, I have two Delhi High Court cases, both of 2021. The first one is the Hero Electric case. Now, the Hero Electric case concerns the Hero brand name. You all know of, I'm sure, Hero Honda, which later lost the Honda and just became the Hero. And you would have in electric mobility, electric two-wheelers, you would have seen the Hero Electric. You would have seen the Vida scooters, Vida electric scooters. Vida is also part of the Hero group. So the reason why you have Hero electric scooters and Vida scooters separately, though they are both parts of the Hero family or the Munjal family, is because of disputes that arose among the family members and the various family businesses that were in existence when the senior Munjal, the father, died, was split into four groups. And by a family settlement agreement and a trademark and name agreement, under which the survivors, the sons, agreed that they would use the Hero trademark for certain products alone. When electric vehicles started becoming a big thing in India and Ather became a success, everybody wanted to enter into the electric two-wheeler market, including Hero. But here, this family settlement agreement and the trademark and name agreement became a problem for the family because two of the groups wanted to enter into this niche electric two-wheeler market and they both wanted to use the Hero mark for their own electric vehicles. So the dispute centered on which Munjal family group had the right to use the Hero brand name for electric vehicles. And this went to the Delhi High Court. Now, one group said, Section 8 of the Arbitration Act, there is an arbitration clause in both these agreements, therefore refer us to arbitration. And we'll see who has the right to use the Hero mark. We'll argue our cases on who has the right to use the Hero mark before the arbitrator. This application, Section 8 application, was hotly resisted by the other group. And the court held that, the Delhi High Court held that the essence of the dispute was not a violation of general trademark law. That is, one group is using the Hero mark without authority or is infringing the use of the Hero mark by the other group. That is not the essence of the dispute. There is a private contractual agreement between both the parties, which is the family settlement agreement and the trademark and name agreement. And your dispute arises out of that agreement. You have to interpret both these agreements to determine who exactly has the right to use the hero mark for their electric two-wheelers. The dispute is not about the grant or registration of a trademark. That is a public function and not arbitrable clearly. But this is a private contractual right between two private parties, and who is entitled to use the trademark is something that can be determined by an arbitrator. Applies the Vidyadrolya fourfold test. The next case again is of the Delhi High Court, the Golden Toby versus Golden Tobacco case. The brand that is in question over here is the Gold Flake cigarette brand. Golden Tobacco is the owner of the Gold Flake cigarette mark, and Golden Tobacco and Golden Toby entered into a trademark license agreement that allowed Golden Toby to manufacture and sell Golden Tobacco's Gold Flake cigarette brand in India. The allegation by Golden Tobacco was that Golden Toby failed to make royalty payments to Golden Tobacco in time. And using this or making this allegation, they terminated the trademark license agreement. Golden Toby did not want the agreement to be terminated, so they filed a lawsuit saying, declare the termination as wrongful termination, and because the contract has been terminated, we have suffered some damages, so we are also claiming the damages that we have suffered. Saying this, they filed a suit, Golden Toby. Golden Tobacco steps in, files a Section 8, says there is an arbitration clause in the trademark licensing agreement, and this is a dispute that has to be arbitrated karke. Golden Tobacco makes an application. So again, the Delhi High Court goes into the question of whether the conflict between the two parties is from a breach of the contract or from a violation of the trademark. And after examining the nature of the dispute, the court comes to the conclusion that the core of the dispute was not about the validity or registration of the trademark themselves, but about the breach and termination of the licensing agreement. You had one party, Golden Tobacco, saying Golden Toby did not make royalty payments in time. You had the other party, Golden Toby, saying Golden Tobacco's termination of the TLA is a wrongful termination, and therefore I'm entitled to a declaration as well as damages. So this trademark licensing agreement between the two parties created rights in personam for both of them, and the question in the suit were those rights in personam and not the public rights, such as the validity and registration of the trademarks themselves. And therefore, this is a dispute that is capable of being referred to arbitration. So post Vidyadrolya, these are a couple of examples of how the Delhi High Court has applied the fourfold test from the Vidyadrolya case. Now, I have so far covered the history of arbitrability and how it connects with intellectual property rights cases in India. Let's take a look at some other countries. I've selected 4 for you. 3 countries and 1 the World Intellectual Property Organization. So the first one is the United Kingdom. They have a strong pro-arbitration stance. In the UK, contractual IPR disputes are arbitrable. Like in India, validity and ownership, that is validity of trademark, registration of a trademark, patent and copyright, and all these things are non-arbitrable. That is my 4th point over here. The case that I will discuss with you about this in this UK context is the Fulham versus Richards case, a 2011 case before the Court of Appeal for England and Wales. The dispute involved the Football Club and David Richards, who was the then chairman of the Football Association Premier League. The FAPL had certain rules, and under those rules incorporated a mandatory arbitration clause. The Fulham Football Club filed essentially a prejudice petition in the court against Sir Richards, stating that he had acted improperly in transferring a player from their club to some other club. And this caused a detriment to Fulham and was a breach of Sir Richard's fiduciary duties under the FAPL rules. And the Fulham club sought an injunction against this transfer and removal of Sir Richards as chairman of the FAPL. Now, what the court held was essentially in this case, Sir Richards comes in and says, this is under the FAPL rules. The FAPL rules have a mandatory arbitration clause, and therefore this is a dispute that has to be referred to arbitration. What the court held was that the dispute between the club and Sir Richards, the unfair prejudice claim under the English Companies Act, can be a subject matter of arbitration. The dispute, although it was centered around company law, English company law, the essence of the dispute was contractual between Sir Richards and the club. And since courts exercise a supervisory authority over arbitral tribunals, the jurisdiction of the court is not, in that sense, overridden. Ultimately, the supervisory authority of the courts are going to be there, even in arbitration. And essentially confirming the position that is there in India today, it was confirmed 10-12 years ago in England, saying rights that are in rem are non-arbitrable, and rights that are in personam stemming out of a contract at their core are arbitrable. Singapore follows a similar approach. Where Singapore has held that contractual IPR disputes are arbitrable. Anything that is rooted in statute or public rights are non-arbitrable. The case that we look at for this is the Tomologan Holdings versus Silica case. This was a case of minority shareholder oppression and mismanagement, something that is there under our Indian Companies Act 2013 also. The minority shareholder, which is the company Silica, sued the majority shareholders, Tomologan Holdings, for oppression of the minority shareholders. The major allegation was that the affairs of the company were being conducted in a manner that was unfair and prejudicial to the interests of the minority shareholders. Tomologan Holdings comes and says there are shareholders agreements between the two of us, and since these are disputes that are arising out of or connected with those shareholding agreements, they must be referred to arbitration. That is what Tomologan Holdings argues in the High Court. And the Singapore High Court agrees with that argument and says that the oppression claim is a claim under the Singapore High Court disagrees with that argument and says that the oppression claim arises out of the Companies Act, the Singapore Companies Act. It is a case, it is a statutory right, and it is a public right. Uh, there are shareholders other than Silica, minority shareholders other than Silica who are involved. And if you are found to be oppressing one particular minority shareholders, it stands to reason that you are oppressing other minority shareholders who are not actually party to the dispute at present as well. Because it involves these third party shareholders who may also require a remedy, including winding up of a company of the entire company, and it is a statutory right under the Singapore Companies Act. This is not something that an arbitral tribunal can determine. Therefore, that lawsuit has to continue in the courts itself. This was taken in appeal to the Court of Appeal, and the Court of Appeal disagreed with the High Court and overturned that ruling and said that minority oppression claims are generally arbitrable because they arise out of essentially the shareholding agreement between the majority shareholders and the minority shareholders. This 2015 case in Singapore established the governing principles for determining arbitrability and non-arbitrability. What Vidya Drolia did for India in 2020, Tomo Logan Holdings did for Singapore in 2015. And essentially, the Singapore Court of Appeal held that it is the subject matter of the case and not the potential remedy that is available, which is the determinative factor for arbitrability or not arbitrability. And Singapore goes a step further in this case and says an arbitral tribunal can be constituted to make a determination on the factual merits, and the court can grant the statutory remedies based on the findings of the arbitral tribunal if it is required, which is a little interesting because this is not something that can happen in India. You have the Sukanya Holdings case, which says that you can't split a dispute between two forums, court and arbitration in India. Singapore takes the opposite view and says, split the process if you want. Let the arbitral tribunal make a finding on the fact. And once that fact finding has been done by the arbitral tribunal, the parties are free to come back to the court seeking statutory remedies such as winding up if they feel it is still necessary. Thirdly, let's talk about Germany. The position remains the same. Contractual IPR disputes are generally arbitrable. Public rights rights questions such as validity of patents or registration of trademark infringement, all this is in the exclusive jurisdiction of courts and are not arbitrable. And there the courts strongly recognize the concept of party autonomy in arbitration. Finally, WIPO arbitration. WIPO is the World Intellectual Property Organization. The WIPO Arbitration and Mediation Center specializes in intellectual property rights disputes under a certain niche, which is domain name disputes, licensing, R&D agreements. They have a panel of neutrals and including expert arbitrators. And we don't know a lot about these cases because they highly value their highly value keeping things confidential. But you can Google WIPO arbitration and get a gist of what they generally do. So WIPO arbitration, WIPO is an organization that has always let us know that arbitrating intellectual property rights cases or arbitration of intellectual property rights is possible. But that again was in the niche of domain names licensing R&D agreements. Uh, so finally, to wind up, uh, my own observations are what appears on your screen. Arbitration is appropriate for IPR disputes that are essentially contractual in nature. Uh, Jurisdiction of the courts and trademark registry, etc., is there for in rem matters like validity of the trademark, registration, cancellation of a particular trademark, objection, and all those things. The law in India today is the Vidya Adrolia case, which lays down the fourfold test, which brings India in line with jurisdictions like the UK and Singapore, where this arbitrability, non-arbitrability dispute was settled in 2011 and 2015. And of course, there are institutions like WIPO, Singapore International Arbitration Center, or SIAC in Singapore, Mumbai Center for International Arbitration in India, which are growing, and the roles of these institutions has been recognized by the Supreme Court, and they do have a role to play in determining IPR disputes. So I'm happy to take questions and questions from the legal specs team.
Hi, sir. Shall I read out a few questions which are on the chat box?
Uh, yeah, sure. You're just Aditya Nilesh has posted a question.
Yes, sir.
Other than this, have you received any other questions? And I saw somebody else had raised their hand.
Yes, sir. Someone had raised their hand. I don't know. Yeah.
Yeah. So Rashank Mishra has raised his hand. So I'll get to Aditya's question first, and then Rashank, you can also put your question in the chat box. So Aditya Nilesh's question is, kindly elaborate on the essentials of an arbitration agreement under the Arbitration and Conciliation Act with regard to IPR disputes. There is no essential as such. When you're drafting, for example, a trademark licensing agreement, if you include an arbitration clause in that agreement, you have requirements under the Arbitration and Conciliation Act. But since you asked this question, I'll go into what Section 7 says is the general requirements for an arbitration agreement to be there. So Section 7 of the Arbitration and Conciliation Act says arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. An arbitration agreement. So first there has to be a agreement between the parties to submit to arbitration all or certain kinds of dispute under a defined legal relationship. That relationship itself need not be contractual. So although an arbitration clause is typically found in a contract, you can have arbitration of tortious disputes as well. Or although an invoice is not strictly a contract, if you include an arbitration clause in your invoice and then give that invoice to your buyer, that becomes an arbitration agreement. The second part to this is how the form of the arbitration agreement is important. So an arbitration agreement has to be in writing. That is the absolutely essential requirement. And what is an arbitration in writing? Agreement in writing is a broad definition. So as long as you satisfy those the requirements of Section 7, Aditya, you're good to go as far as IPR disputes are concerned. The second question is from Owais Malik. Uh, how workable is the fourfold test in practice when applied to IPR disputes, where the boundaries between private rights and public policy often blur? Uh, it is completely workable. Uh, we have seen it being done even practically even before the Vidya Drolia case, and certainly after the Vidya Drolia case. I'm referring to the 2016 Eros versus Telemax case for the Bombay High Court, uh, the Hero Electric case, and the Golden Toby cases of the Delhi High Court, both pre and post Vidya Drolia. How does India's approach to arbitrability of IPR disputes differ from jurisdictions like US, EU, or Singapore? I think I've covered that in the slides. Post Vidya Drolia, post 2020, we have now pulled up our socks and come in, uh, defined ourselves more along the lines of international practice. Rashank Mishra says, does arbitrators decided by party or can court also decide? It works both ways. Ideally, an arbitrator is to be appointed by party agreement. If parties cannot agree on an arbitrator, then the courts will step in and appoint the arbitrator for the parties. See Section 11 of the Arbitration and Conciliation Act. Uh, Another question from Uwais Malik. Do you think India should amend its arbitration framework or IPR statutes to explicitly allow certain IP disputes to be arbitrated, similar to the way WIPO promotes IP arbitration globally? No, I don't think so. Uh, the more specific you make things, the more danger it is of getting a narrow interpretation. I think the interpretation that we have post Vidya Drolia is good enough to be extended to IPR disputes, and that is the way it should be. Uh, Yashoda Rajput says, what challenges do parties face when choosing arbitration for IPR disputes, confidentiality, enforceability, or expertise of arbitrators? There are no challenges per se when choosing arbitration for IPR disputes. Arbitral awards, the entire arbitral process is confidential by nature. Arbitral awards are enforceable. As far as expertise of arbitrators is concerned, you parties can always agree in their arbitration clause itself that the arbitrator to be appointed between them to determine that intellectual property right dispute should be a expert in the field. So you could have somebody from say the WIPO panel or something of the sort. Uh, uh, we have Owais Malik again with a question. From a practitioner's perspective, what safeguards would you suggest in arbitration clauses involving IP rights to avoid later challenges on grounds of non-arbitrability? I think this is a good question. As a safeguard, something that I generally include in contracts that I am negotiating on behalf of clients is uh, clarifying the scope of the arbitration clause. So if you, rather than having a generic arbitration clause in your trademark licensing agreement, for example, If you say, if you have that generic arbitration clause, there is no problem as such. But then you can always include the clarification saying that the questions that are capable of being determined by the arbitrator or fall within the arbitrator's jurisdiction are all questions that arise out of or are in connection is a little vague. You can specify the scope of the arbitrator's jurisdiction in the clause itself. That always works. But the danger with doing that is it is a double-edged sword. The moment you specify the scope of the arbitrator's jurisdiction, the arbitrator can no longer step out of bounds. And if he makes a determination on anything else, that award is liable to be set aside because there will always be the argument that the arbitrator has exceeded the scope of his authority. Uh, if Rashan Mishra, if one party not satisfied with the arbitrator's decision and which court he can appeal, read Section 2 and Section 34 of the Arbitration and Conciliation Act. Both which Section 2 defines the court and Section 34 defines the nature of the appeal. It's not really an appeal, it is a challenge to the award. Suppose two Indian companies sign a contract with the seat of arbitration in London. Will Indian courts still have jurisdiction? No. So again, this is an interesting question by Arpita. Earlier, before 2015, the position in India was two Indian parties cannot agree to have an arbitration outside India. So when you say seat of arbitration determines the supervisory authority of the courts in that particular place. That is the importance of the word seat. So pre-2015, the position in India was that two Indian parties cannot seat their arbitration outside India. They necessarily have to seat their arbitration within India itself. After 2015, the Supreme Court stepped in and clarified. It started out with the Madhya Pradesh High Court. The From the Madhya Pradesh High Court, it went to the Supreme Court, where it was clarified that two Indian parties can arbitrate abroad. And if the seat of arbitration is outside India, Indian courts will not have jurisdiction over the arbitration itself, but at the time of enforcement, they will obviously have jurisdiction. Pawan More says, counterfeit control kaise kare, sir? I'm not sure what you are answering, what you want me to answer, but I didn't follow the question anyway. If we have, if Owais Malik again asks, with the global increase in technology and digital content disputes, do you foresee India moving towards a specialized IP arbitration mechanism, maybe akin to a WIPO center in the region? No, I do not. If there are no further questions, I think that's my time.
Thank you so much, sir, for sharing your invaluable experience and everything, all of the cases with us today. Your insights have been incredibly enlightening and have shed light on this really complex topic. And to our audience, thank you so much for your active participation throughout the entire webinar. A feedback form has been shared by Sanjana on the group. And Sir has also shared the presentation as well. You could download that. And only if you fill the feedback form will you be eligible for certificates. With that, thank you so much, sir. And to everybody else who's joined, I hope you have a great evening. Sir, I'll connect with you later in a few minutes.
All right.
Thank
See
you,
you.
sir.
Bye.
Bye. Okay, those of you who've not, one second.